All right, good morning, everyone. I'm Robert Montgomery. I'm from Sullivan County, and I'm here to preside over the Tennessee Court of Criminal Appeals September docket here in Jackson. To my right is Tim Easter, who is from Williamson County, and to my left is Tom Greenholz, who's from Hamilton County. When we have argument, if you're the appellant and wish to reserve any time for rebuttal, please let us know. Are we working the
yes,
counter, so to speak, yes. Clock? All right, so be observant of that. But if you want to reserve time, please let us know at the very beginning. Now, Madam Clerk, are there any preliminary matters?
No, Your Honor.
Okay. Would you call up the first case then, please?
Quadarius, Devonta, Bufford versus State of Tennessee.
Okay. Ready to proceed?
Yes, Your Honor.
All right.
I'd like to reserve 4 minutes for rebuttal, please. May it please the court, my name is Cynthia Chandler with Chandler Law Firm over in Medina, Tennessee. I am the court-appointed counsel for Quadarius Bufford, and I mention that because it may be relevant in some of the arguments today. As you know, this is a post-conviction appeal. My client was convicted back in 2015 by jury trial of first-degree murder perpetration of the crime of child abuse. He was convicted, he did appeal, and then permission to the Supreme Court was denied. In the brief, we have 4 issues that we've highlighted for the court's review. In the interest of time, and with your Honor's permission, I would start with issue number 2. And the reason I've chosen that is because really all of the issues tie back into the argument of ineffective assistance of counsel.
Before we go forward on that, let me ask you a couple of questions, because I had a chance to look at the opinion on the direct appeal. And in there, it says that at the motion for a new trial, the defendant raised the issue of ineffective assistance of counsel. And at the motion for a new trial, there was a hearing, and the defendant's attorney argued ineffective assistance of counsel issue at the motion for a new trial. And then the trial court denied the motion for a new trial. And in fact, that fact was referenced in the direct appeal. Now, the question that I've got is if ineffective assistance of counsel was raised in the motion for a new trial, and then the judge down there ruled on it, I think a defendant is precluded in a new post-conviction petition of raising ineffective assistance of counsel. Have you an opinion on that?
Well, Your Honor, I have not researched that specifically, particularly because the trial court judge did not, that was not addressed in the post-conviction hearing, and I don't think it was raised by the state.
I mean, I know you didn't handle it initially, so that's...
Right. But I would submit that based on the constitutional issues that are brought with the ineffective assistance of counsel, that it's within this court's prerogative to be able to allow that.
Well, there's a lot of case law out there that say that by raising the issue on direct appeal and arguably in the motion for a new trial, that you're precluded from then raising it in a post-conviction petition, because the code sections dealing with post-conviction say that if a ground for relief is previously determined, if it's been determined by a court of competent jurisdiction who has ruled on the merits after a full and fair hearing, then you can't raise that issue again.
I suppose our argument then would be that there was not a full and fair hearing on that issue with the trial court.
We may have to go back and look at the transcript from that trial, and I'm sure, and the motion for a new trial from that. And is issue number 2 with regard to the attorney was ineffective for not securing an expert?
Yes, Your Honor.
Okay, so again, that's, even though the trial judge may not have dealt with that specific issue, the trial judge arguably on the motion for a new trial dealt with ineffective assistance of counsel, so that may fit under that same problem that we might have.
Yes, Your Honor. On that issue of the medical expert, the issue number one in our brief was related to that, but not precisely what was brought up at trial. The fact that one was not allowed, and then the issue of whether a defendant or a petitioner is entitled to have an expert at the post-conviction level, due to that being the only way you can prove that the medical testimony, what it would have been and whether it would have made a difference. I think that ties in a little bit. It might make it a different issue here,
Okay.
arguably.
All right. Anyway, I just thought I would ask you about that, if you had some thoughts on my issue with regard to it being raised
Thank you, Your Honor.
previously.
On that issue about an expert for post-conviction, I'm not aware of any case law that supports that position. In fact, most of the case law that I've looked at says just the opposite on a non-capital case.
You are correct. I did find some information out in California that they actually set up a different type of process under their state constitution where defendants were entitled to request that. But generally, you are correct. I think everyone's familiar with Strickland standards, so I won't be redundant by repeating them here. I think the question here will be the two prongs of whether there's deficient performance by counsel and then whether there was resulting prejudice. We've touched on the issue, I think, with the defense counsel's failure to retain an expert witness, and I will, continue to discuss that, particularly with the issue raised in number one in our brief. Counsel did actually make the effort to talk to an expert witness, Dr. Lisa Piercy, who's well known, particularly in our area. Dr. Piercy, according to defense counsel's testimony at the post-conviction hearing, did have an explanation that supported the defendant's position of how this happened, which was that it was accidental. I think it speaks for itself that the reason defense counsel reached out for an expert is because one was needed in this case. The state had 3 expert witnesses in the medical field. One was the emergency room doctor. There was also the doctor who performed the autopsy and one other doctor. And while we know that juries are instructed not to count the number of experts and weigh those, 3 to 0 is a pretty strong number, and defense counsel recognized that and sought to find expert testimony. The reason that defense counsel didn't proceed with that expert testimony is because Dr. Piercy would not sign the confidentiality non-disclosure agreement. Now, the state says that that was reasonable because had Dr. Piercy's overall evaluation been negative for the defense, that would have added yet another expert for the state's side. However, I think the difference between 3 and 0 and 4 and 0 is really worth the risk there. The cards were already stacked against the defendant with state's expert proof, and it was clearly needed in this case to establish that the defendant's accidental explanation could in fact be plausible. Without that, there was no testimony brought by defense counsel except for that of the defendant.
So was it Dr. Piercy's position that she would not testify without this non-disclosure or no confidentiality agreement?
In fact, the opposite. Defense counsel would not use her if she didn't sign the non-disclosure agreement. So it was defense counsel that was insisting on that as part of the public defender's office protocol. And I'm not sure if I don't think that's an established rule. I think it is specific at least to that office or to public defender's offices in general in the state of Tennessee. And there's no evidence that any exception was sought.
How do we know what her testimony would have been?
Because defense counsel who spoke to her initially testified at the post-conviction hearing. So it is on the record that she had told him preliminarily that she reviewed the records and that by her medical opinion, these injuries could have been caused by an accident described in the way the defendant described it.
She was not called at the post-conviction hearing, though, is that right?
That's correct, and that goes back to the Rule 13 funding issue. The client is indigent and did not have any funds to secure an expert. Dr. Piercy was available but not willing to work for free, which is certainly understandable. And the post-conviction counsel did file a motion with the judge asking for funds for the expert, and they were denied under the rule.
She would have been, I suppose she would have been a witness at the post-conviction hearing. Was she subpoenaed to testify?
She was not. I believe that post-conviction counsel, I was not the one that had that hearing, had spoken with her and learned of what her retainer was and went from there.
Okay.
Moving on, I guess, to the, or further into the issue of ineffective assistance, one of the allegations, it was a tangential allegation, I guess, is that there could have been some sort of sexual abuse of this child. Now, I think, at least from my experience, and probably I think we can all take notice that allegations to sexual abuse can be extremely prejudicial in front of a jury, particularly when that's not a crime that the defendant is charged with. Defense counsel in this case at trial did not file a motion in limine to keep reference to that out. It was included in the records, injuries to the anus, and defense counsel was aware that it might come out. Defense counsel filed a motion on uncharged conduct rather than a motion to suppress. The motion on uncharged conduct was never heard. Defense counsel had kind of a gentleman's agreement with the prosecution that they weren't going to bring up any uncharged conduct. But during the trial of the matter, there was reference to sexual abuse or anal injuries from Dr. LeBoy, one of the medical experts. 3 times the anal injuries were discussed. The DCS worker testified about her sexual abuse training in addition to her physical abuse training. Dr. Lakin, another expert, had 27 lines of testimony about the anal injury, and I believe it was LeBoy that said this was concerning and indicative of sexual abuse. So it definitely came in. No objections were made, even though defense counsel knew that that was a possibility that it would come in, and defense counsel had made some sort of attempt to keep it out, but then when it came in through the testimony, there were no objections.
So your friend on the other side says this issue is waived. I think he says it's waived because it was not included in the original petition or the amended petition. What's the best response to that?
In the original.
Yeah, I think what the state is saying, I think if, and General Coleman can correct me if I'm wrong, but I think the state is saying that to raise an issue in post-conviction, it had to be alleged in the original petition or in the amended petition, and that if the claim is not raised, then the court itself doesn't have anything before it to rule on it, so therefore the issue is waived in post-conviction. What's your thought?
Sorry.
No, go ahead.
I would argue that the ineffective assistance of counsel was raised, and perhaps the specifics of each element of that were not raised, but I do believe it's been included.
Sure, but with respect to maybe this instance of ineffective assistance of counsel, is this instance waived? Because it was not included in the original or amended petitions?
I would still say that, as you know, a bare bones petition is sufficient to get before the court, and I don't think that any of the specific allegations have to be included. I would say that the sexual abuse issue could be incorporated under several of the other issues that were included in the petition and amended petitions.
Did the DCS investigator testify at trial that there was not sexual abuse?
The DCS investigator did not testify about sexual abuse at all, one way or the other.
Okay, so the DCS investigator did not rule out sexual abuse as being the reason for the injuries?
It's interesting, the DCS investigator in this case, first of all, wasn't disclosed as being a witness, and defense counsel hadn't spoken with her beforehand and did not object to her being called. When DCS was brought to the stand, she gave her background in physical abuse training and sexual abuse training. but her actual testimony was related to coming to the home around, I think, a month earlier on a complaint or a call-in about potential physical abuse. So one of the other arguments that's included in our petition is that the DCS testimony was irrelevant and perhaps, I think, very harmful, because DCS was not called in on this incident, and this incident was not related to, the case was already closed on the previous incident. There was no evidence found of any type of abuse at that time. Did that answer your question?
It
I'm
did.
sorry.
Thank you. Thank you very much.
Further, I'll just go back to, we have the prosecutorial misconduct argument, and that also, I think, goes into the ineffective assistance of counsel argument. I know that we have great leeway in, particularly in closing arguments. However, if you look at the particular language that was used by the prosecutor, in fact, calling him a lying baby killer, pretty inflammatory, quoting the Bible in certain circumstances, liar, liar, collaborated with your lawyers and made up this story. And then I think probably most damning is when the prosecution said, if you have a not guilty verdict, you are telling Braden Taylor's family that his life meant nothing.
I need to ask you another question.
Yes, Your Honor.
All right, in the direct appeal of the convictions, did the counsel for the defendant raise that issue of the lawyer's prosecutorial misconduct in the closing?
No, Your Honor, I do not believe that prosecutorial misconduct was raised in the appeal.
So, but that would have been an opportunity for the defendant's counsel to raise that issue, correct?
Yes, Your Honor, it would have been.
And so doesn't the case law generally say that if you, but statute maybe says it too, that if you have the ability to raise it, let's say on direct appeal, and for whatever reason you don't, haven't you waived it?
In response to that, what I would say is that even if it were waived as an independent factor,
Right.
I think that goes into the ineffective assistance of counsel, which should be is guaranteed at both the trial level and the appellate level.
Right. Okay.
But we'd be reviewing it through the lens of the Sixth Amendment instead of on its own merits, though, right?
Yes, if that were found to be waived. Thank you.
All right, thank you. General Coleman?
Good morning, Your Honors, and may it please the Court. Ronald Coleman on behalf of the state. This Court should affirm the denial of post-conviction relief. First and foremost, to your point, Judge Montgomery, about the direct appeal, that was something that I completely missed. I do not have the transcripts in front of me. This Court can take judicial notice, and I have seen that this Court on direct appeal ordered a copy of the transcript for the motion for new trial. So we submit that if this Court chooses to take judicial notice and it was fully fleshed out and ruled upon by the trial court at the motion for new trial, then the petitioner is not entitled to a second bite of the apple.
Does it have to be that? I thought that a full and fair hearing was merely the opportunity to call witnesses and offer evidence.
I think this court could say that by presenting, and I think in its direct opinion, this court noted that the petitioner sort of labored on claims of ineffective assistance of counsel. So at that point, we would submit that they had the opportunity for a full and fair hearing, and again, are not entitled to a second bite of the apple, and this should be dismissed as an improper second petition for post-conviction relief, or well, not a second petition, but as having previously raised the ground.
Wouldn't it be previously determined?
I believe so, because the petitioner is arguing that, well, we didn't raise this medical expert or any specific instances, but those are grounds for the claim, the singular claim of ineffective assistance.
So to follow up on what I understand you're saying is that, for instance, in the motion for a new trial, at which it's alleged, at least the record seems to affect, there was ineffective assistance of counsel that was argued in the motion for a new trial. The fact in that motion for a new trial argument, there was no discussion about an expert not being retained, or that the counsel didn't object to what the state's attorney said in closing argument, because those both fit under ineffective assistance of counsel, even though they weren't specifically raised, you still can't raise any form of ineffective assistance of counsel.
That's correct. This court has sort of repeatedly held that ineffective assistance of counsel is in and of itself a singular claim, and that there could be multiple bases for relief under that, but it's a single claim. And so if that claim was presented at the motion for new trial and was ruled upon, they had a full and fair hearing, it's been previously determined, they cannot raise claims of ineffective assistance of a counsel again here.
Well, I've got the quote out of the, and you may have looked at it today, the direct appeal, that quote that essentially says, at the hearing for motion for a new trial held on January 8th and February 23rd of 2018, the defendant's counsel argued only the ineffective assistance of trial counsel issue. And on February 23rd and again on April 2nd, the trial court entered orders overruling the motion for a new trial. So at least that reference seems to suggest that indeed that was the issue that was talked about in the motion for a new trial.
Yes, Your Honor. It certainly seems to have been litigated. My only potential hesitation would be as to what the trial court ruled on in the motion for new trial. But ultimately, we would submit that if this has been presented to a trial court and litigated and ruled on, then the petitioner cannot raise that claim of ineffective assistance again here. And all of those grounds are waived.
With regard to the argument, or excuse me, the challenge to what the state may have said in closing argument, and you're not talking about perhaps ineffective assistance of counsel, but you may be talking about denial of, well, anyway, that issue, if, again, you had the opportunity to raise it on direct appeal and you didn't, then is that a post-conviction issue?
It is
for
waived.
us to consider. Is it waived?
This court cannot consider it. We've presented that in our brief. Tennessee Code annotated 4030-106, I believe G, says if it could have been presented at an earlier opportunity, and here the defendant readily had the opportunity to present this issue on direct appeal, then it is waived. So as a standalone claim of improper closing argument, that is waived, and that is not for this court to determine.
Even though it would have been under plain error on appeal?
Yes. It still could have been presented. It doesn't have to be presented for plenary review. We would submit that as a standalone claim has been waived.
As I understand it, though, it makes sense to me that at the motion for new trial, if the claim of ineffective assistance of counsel was raised, then that was a different attorney than trial attorney.
Then appellate counsel, yeah.
That would be appellate counsel.
That logic would follow. Although this court has
And then
recently
appellate counsel fails to raise the issue of prosecutorial misconduct on appeal. Then it's waived against him or her as well? You see what I'm saying?
I understand that. This court has specifically commented on the dangers of raising
Sure.
ineffective assistance of counsel. I think that might be the case to the extent that ineffective assistance of appellate counsel is potentially a separate independent claim. It's not been raised here. It's
It
been
has
waived.
not been raised here. I
Yeah, I was
recognize
going to say that I didn't read anything to suggest that they're claiming that appellate counsel was ineffective.
It was briefly mentioned, I believe, in a footnote in the reply brief, which is not sufficient to preserve it for the review. So appellate counsel was not challenged in the trial court or in the post-conviction court.
Post-conviction.
So we don't really have any issues with what appellate counsel did here. Unless this court has other.
Well, I have another
Yeah.
question. So, General, as a result of the questions we're talking about where it appears that there's a good chance that it was raised in the motion for a new trial and ruled upon by the court, is that an issue that you feel like you need to brief for us?
We would certainly be happy to, Your Honor. We could get a copy of the direct appeal record and make a brief. If this court wanted supplemental briefing, we would be happy to.
It's a question of jurisdiction, isn't it? I mean, if an issue's been previously determined, in this case, the ineffective assistance of counsel, that goes to the very jurisdiction of the post-conviction court, doesn't it?
I think because it's an issue, the court would still have jurisdiction to hear some petition for post-conviction relief. But whether it would, My understanding of of Section 106G is that it is waived, not necessarily a jurisdictional thing. If this court wants to find it's jurisdictional, it can. I don't have the research in front of me to make any further comments on that, though. But, either way, if it had been presented, it's certainly not properly before either the post-conviction court or this court, and it should, at a minimum, find it waived or find that the court had no jurisdiction to rule on the ineffective assistance of counsel claims. And again, if this court wants Bristol briefing, we are happy to do that and sort of dive into this.
It's more like the question whether or not you feel like it's appropriate for us to
I mean, I
receive
think the
that
court's
briefing.
offering you the opportunity, and so the question's really up to you about whether you wish to take it.
Certainly, Your Honor. If we have the chance to, we would love to dive into this and file additional briefing and supplemental
Both
briefing.
sides as well, certainly.
We can do that relatively quickly if this court would like, or at least provide maybe a notice of supplemental authority or point to the direct appeal record where it has been ruled on. But certainly that will maybe be more fleshed out in a supplemental brief. But if this court doesn't have any further questions on sort of jurisdiction or previously determined, I'll briefly address the various grounds of ineffective assistance of counsel that were presented today, because this court can easily deny relief just on the merits of those two if it chose to.
So General, I asked your friend about whether the claim with respect to the sexual abuse or the alleged sexual abuse was waived because it was not included in the original or amended petitions. Is that the state's position?
I think a combination of the fact that it wasn't fully fleshed out in the initial or amended petition, the defendant didn't present proof of the objections, because I think the defendant is trying to combine two different claims. One is the failure to file a motion in limine prior to trial to exclude alleged references to sexual abuse. One is failing to object at the time of trial to these alleged instances. And so I will note in the second amended petition, the sort of subheader discusses that counsel was ineffective for failing to file the motion in limine or to object. But by the time it got to the post-conviction evidentiary hearing, the testimony focused almost entirely on the failure to file the pretrial motion, and the post-conviction court only ruled on the failure to file a pretrial motion.
Well, I thought the post-conviction court actually addressed the objection part. And didn't the post-conviction judge say that the objection likely would have been sustained?
So that is a different objection.
Okay, what's that objection related to?
That the trial counsel should have objected to the state's closing argument.
Okay, very well.
So it's a separate claim.
Okay, thank you. That's very helpful.
So to the extent that it is failing to object to mentions of alleged sexual abuse at trial, we submit that that's waived.
Okay, very good. That's good, thank you.
But getting to that claim of this failure to object to alleged instances of sexual conduct. All right, well, I'll start with the first. Failing to obtain apologies, I lost my place, Your Honors. Failing to file a motion in limine to exclude sexual abuse. Counsel first was not deficient. He testified that he had an objectively reasonable reason not to do so, which is that the state told him they didn't intend to present proof of sexual abuse. And that sort of goes in line with what the proof showed at trial. Yes, Dr. LeBoy, the doctor who examined the victim here, testified that the victim suffered injuries to his anus, but that was in conjunction with all of the additional injuries, and he didn't provide any opinion as to what could have caused that. So that's not evidence of sexual abuse in any way, or even allegations of sexual abuse. That is just a observation of an injury that the victim suffered as a result of this physical abuse. The petitioner points to this DCS worker, and to your point, Judge Greenholtz, as to what the DCS worker testified to. She discussed, and this is on Volume 5, Exhibits, I believe, 7. This is page 67 of the trial transcript. It was admitted as an exhibit. The DCS worker testifies that she went, had investigated allegations, and then at the bottom of page 67, question is, for lack of a better term, did anything come out of that investigation? Was anyone accused of anything? And she responds, no. So she testified, to the extent that she discussed allegations of sexual abuse at all, she explicitly told the jury there was no proof. There was a lack of proof. So that's, again, not allegations of sexual abuse or not discussions of that. And again, the additional doctor who testified, to the extent she testified about her training, that was to qualify her as an expert. And to the extent she made a passing comment about the bruising of the victim's anus and how that was sort of threw up a red flag, she still never made allegations. The state never exploited that. Counsel was not deficient for choosing to not file a pretrial motion or declining to object to any of these instances. And then again, there is no prejudice here. The petitioner hasn't established how this would have changed the outcome in any way. The petitioner also complains about counsel's failure to get an expert. And so counsel explained that he did in fact go and meet with an expert. He talked to this individual, and your question, Judge Easter, what he testified to was that the doctor would not sign a confidentiality agreement, and he would not move forward because if she gave some opinion testimony that was unfavorable to the defense, she could run to the state and be an additional witness. That's a reasonable strategic decision. The petitioner, I think I heard my friend on the other side today submit that the trial counsel said this doctor who he at least consulted with opined that there was that it would be favorable, or gave information that would be favorable to the defense. That's not my understanding of the record. The entirety of the discussion of talking to this expert is on volume 3, pages 90 to 91. And I did a brief skim and was unable to see anything that discussed what her opinion might have been.
So, General, can I go back once again to the issue about the alleged sexual abuse and the anal injuries? I thought, and I'm pulling this from volume 3, page 143, where you were talking about the court saying it would have sustained an objection to the closing argument, that the paragraph immediately before that, the court says this: again, as to the testimony about the injury to the anal area, frankly, I don't see that an objection would have been sustained, just as to the question of what the injury was. That looks to me, and that's what I thought the record had represented, that looks to me like the court is reaching the merits of the issue.
I think it did. I might have misunderstood your question as to whether it would have been sustained. Okay. The court here is commenting that it would have overruled the objection. I don't see that an objection would have been. So I can't see that me sustaining this objection. So again, there's no prejudice, because if he had objected.
Sure, I think I was going back to the point where the state was alleging that the issue had been waived. And I think what I was trying to probe a bit was whether there had been evidence offered and the court had issued a ruling, and so therefore it had not been waived.
I think that might have been enough to make it not waived.
Okay.
Judge,
okay. That's fair enough.
Seeing that now, we're happy to withdraw that and allow this court to rule on the merits of it. But certainly, both with the failing to object to alleged instances of sexual abuse or failing to obtain a medical expert, the counsel was reasonable, was not deficient, and the petitioner can't establish deficiency. He hasn't argued that a motion in limine would have been sustained or would have been granted. The trial court expressly apparently found that it would have overruled any objections, and the petitioner has failed to call any expert. So under Black v. State, he simply cannot meet his burden of establishing prejudice.
The petitioner raises just, look, this is unfair. It's absolutely unfair. The AOC won't pay for an expert in post-conviction proceedings, yet your law requires me to present an expert at the post-conviction proceedings to get around Black versus State. The Supreme Court recognized that in Davis.
Exactly.
And this court has recognized the inherent unfairness to it. And I don't think, but correct me if I'm wrong, despite this court being invested with judicial power, I don't think we have the ability to declare a Supreme Court rule unconstitutional. I think only the Supreme Court has that authority.
I agree, Your Honor. I think this court is bound by the Supreme Court's both rule and precedent, where they have found that this is permissible. that the denial of expert funds to non-capital defendants or petitioners is just acceptable. And
So that even if the AOC will not provide funding for an expert in non-capital post-conviction cases, Black v. State still governs, and where you didn't call the expert, you're out, right?
Yes, and I understand that that makes things more difficult for petitioners, but there are still opportunities for them to be able to call experts, either retaining them themselves or finding people who will work pro bono. So there is the opportunity still. And again, just the Supreme Court has repeatedly held that this is acceptable. I did want to get to, I think, the last claim that the petitioner raised, sort of in conjunction with the standalone claim of closing argument, to the extent that they also alleged that counsel was ineffective for failing to object. And the trial court explicitly, or the post-conviction court explicitly accredited trial counsel's testimony that this was a strategic decision. Counsel testified, I know this prosecutor, I've interacted with him before, I've done trials with him before, I know he gets, and I believe he used the word quite vehement, I know he goes way over the top. I intentionally wanted the jury to see that, and I wanted them to see my calm, professional demeanor so that it would work against him, that they would say he's really going above and beyond and making a mountain out of a molehill. That's a reasonable strategic decision. Maybe if counsel, in hindsight, would have wanted to object, that's fine, but when you have the strategic decision, this court defers to it, and it's virtually unchallengeable per Strickland.
Counsel did testify at the post-conviction hearing that he should have objected, and this is not a case where you've got 2 or 3 mentions. I mean, you have a dozen, right?
It's certainly a lot. The counsel could have objected, and again, with the benefit of hindsight, counsel said maybe I should have. But that's not the standard, and that's not how we review it. We look at the decision at the time. Is it reasonable? Is it objectively reasonable? And counsel said, I had a strategic decision. I had a basis. The court accredited that testimony, and state submits that that is completely reasonable, allowing a prosecutor to sort of go off the rails and presenting a calm and cool demeanor could have worked for counsel. The fact that it didn't doesn't mean that he was deficient there. Unless this court has any further questions, we'll rest on our brief for the other issues and certainly get a supplemental brief on whether the issue has been previously determined. In the interim, we ask that this court affirm the denial of post-conviction relief. Thank you.
You said he could do it pretty quick.
Thank you for the opportunity to rebut. I'd like to just start with the statements about Dr. Piercy and what her testimony would have been, which I know is relying upon the statements of trial counsel at the post-conviction hearing. But page 17 of our brief goes into the testimony in volume 3 that trial counsel gave about Dr. Piercy's, his conversations with Dr. Piercy's, and it did say that her testimony was promising for the defense, gave an informal verbal opinion to trial counsel that contradicted the proof that was going to be put on by the state, again, according to trial counsel, and that perhaps most importantly, the injury to the anal area was, which they had referenced as concerning for potential sexual abuse, was actually related to a blowout caused by trauma to the abdomen, which forcibly damaged the child's anus at the time. So for those reasons, we think that that testimony of defense counsel was sufficient to show what the positive nature of Dr. Piercy's potential testimony. We've had a lot of issues that we've discussed about who was alleged to be ineffective when. And I just want to go through for the court, as the record will reflect, that Mr. Bufford had trial counsel. He had different counsel for the motion for a new trial. He had different counsel for the appeal. He had different counsel, 2 or 3 different counsels on the petition for post-conviction. And he had me as counsel for the post-conviction appeal. Now, I think it's well established that you don't actually have a right to effective counsel at the post-conviction proceedings, but if you look back at the trial counsel, the motion for new trial, and the appeal, then I think it's easy to see how allegations of ineffective assistance of counsel may seem redundant or repetitive, but they're actually not, because my argument, I think, would be that if counsel at the motion for new trial included ineffective assistance at that point, that he did a poor job of including everything that needed to be included, which is now being heard before this court in the post-conviction appeal. Same for counsel for the appeal, who does have the responsibility to be effective, did a poor job of including or addressing those issues at that time. So that would be my response there.
So before this petition was even filed, if I understand what you just said, there were 3 separate attorneys: trial attorney, motion for new trial attorney, appellate attorney.
Yes, Your Honor.
Am I incorrect in that your claims in your post-conviction petition only attack trial attorney?
They do only specifically attack the trial attorney. I think we could have been more explicit in the allegations that the appeal counsel and the counsel for the motion for new trial, by not addressing the ineffectiveness of trial counsel, actually themselves became ineffective. And I do agree that that's not the clearest of issues from what we have filed. If there are no further questions.
Ms. Chandler, I know you mentioned, and the record reflects, you were appointed on this case.
Yes, Your Honor.
I know I speak for my colleagues when we appreciate your taking the case.
Thank you very much.
Since we had talked about supplemental briefing, General, I was looking at a calendar. Would 2 weeks from yesterday would be September 22nd. Would that give you enough time?
That would be the state of the time, Your Honor.
Okay, and then what I'll do, counsel, is say give you 2 weeks from that date, which would be October 6th. We'll put down an order to that effect, but yeah. So, General, September 22nd, and then council October 6th. All right, thank you all for your time today. Y'all ready?
Yes.
Would you call the next case then, please?
State of Tennessee versus Rebecca M. Davis.
Is that okay?